My lord,
kindly
an
elaborate a bit more on
example of that is the Bas Kakar case. It's a classical example as to why the Supreme Court struck down that law. What in the Bas Kakar case, the Contempt of Court Act 2012 did, is that in terms of actual cases pending before a particular judge, in which that judge had taken cognizance of, for example, a contempt on the face, in that, legislature interfered and that said that that case will go before another judge.
That's not practice and procedure. That's not
No,
practice.
but
and
I'm saying
procedure.
that is that.
No, but Bas Kakar was decided in the context of Article 204.
No, no, I'm giving you an example.
But that was a different context. Give me an example of 191 when you say.
I'll give you an example.
Colonize or abrogate.
I'll give you an example. Let's take section 2. If there was any role.
आप जरा स्पेसिफिक एग्जांपल नहीं मुझे जरा पहले इस प्रिंसिपल को जरा समझाइए
वही मैं प्रिंसिपल
आपकी लिमिटेशन
मैं एक एग्जांपल से प्रिंसिपल को let's say that section 2 envisaged some kind of role of the executive in the constitution of the bench. That I would say would be a violation of 191 and the principle of the independence of the judiciary.
I would regard section 2 I mean section 3 actually.
सेक्शन 2 सर कमेटी जो बनती है एक कमेटी मेंबर चीफ
3 में है ना
जी 2 में है ना 3 में तो वो है ना सर मेंटेनेबिलिटी वाला सर
सॉरी 2 में है I would regard that as colonizing the
I know your lordship comment about
you used very interesting words colonize तो colonize
बस ये लिटरेचर पढ़ के थोड़ी सी गलत
हो गया ना इसको इसलिए मैं आपसे ये you're making an interesting point but I want you on the plane of principle kindly to this point further.
Sir, this cannot be preemptively elaborated. This can only be understood through example because one doesn't know. Your lordship has to examine this provision by provision. That is why what I would be suggesting that there is a debate between that we should open the door and not be afraid of it, and there is a suggestion about closing the door. I would say keep the door open, but there should be certain padlocks on it.
The other way is that you keep the door open, but the watchdog is sitting.
Yes.
And watchdog ensures that nothing, fundamental rights are not violated. So all your 5 points could be summed up by saying that as long as that law doesn't violate the fundamental rights, which includes access to justice, independence of judiciary.
Siddiqui sahab,
ये जो आपने बात की है second, ये आपका जो second है, how does that square with the implied repeal? आपका ये जो second point है ना? Secondly, the court cannot colonize or abrogate. आपने अभी कहा कि implied repeal is possible.
Yes.
Kindly explain to me
Sir,
how. As a principle, principle की बात
sorry.
करें. I mean, don't go into the nitty-gritty right now. वो तो आप आगे जाके करेंगे. मैं आपका principle समझ रहा हूँ. How does this square with the? You say there can't be express repeal, but how does this square with implied repeal?
No, sir. There can be express and implied. What Mr. Salahuddin argued that the Parliament can get rid of the entire Supreme Court rules. I'm not advocating that on a particular rule.
How do we identify the core that cannot be repealed?
Yes.
Mr. Faisal, the core would be that in case, Mr. Salahuddin might be correct, you see, they can strike down the entire set of rules provided they don't violate the independence of judiciary. Your argument is the same.
No.
Why stand on any provision? Suppose theoretically speaking, if you bring out a law which takes away all the rules that are there, but it doesn't affect the independence of judiciary, maybe enhances the independence of judiciary, what's wrong?
My lord, I think what is underlining 191, and this is something which should be safeguarded at all circumstances, is at the heart of 191 is not the law made by Parliament, but the internal autonomy of the Supreme Court.
There has to be some
Siddiqui sahab, my question, please. ये आर्टिकल 191 की जो लैंग्वेज है that starts with subject to the law in the constitution. There are very few articles of the constitution which starts with the word.
There are only 3.
Only 3. Yes. So does it means that because the constitution was framed in 1973 and the rules were framed in 1980, do you think that there is still a room is left for the improvement in the procedure with the passage of time? Like 184.3, whenever it has been used, पूरे मुल्क की बुनियादें हिला दी उसने जब भी इस्तेमाल हुए. So, do you think there is a room left for improvement in Article 184(3) or the procedure of the Supreme Court?
My Lord, I think
intentionally that has been done.
Whatever amendments, and I'll take your ladyship through each of the amendments, whatever amendments have been done, I think that shows that reform is required under Article 184(3).
So can I just understand? आप ये कह रहे हैं कि 191 enables Parliament to make law.
Yes.
The principle to apply will be the independence of the judiciary. So the independence of the judiciary and the ability to make rules should be protected and preserved. But Parliament can make law with reference to practice and procedure.
Yes.
If they do make that law with reference to practice and procedure, so that's not undermining that principle of independence of the judiciary, but then we then go into the provisions that
yes.
they'll start making of practice and procedure, and so then see whether that meets. So then my question is that isn't the constitutional mandate the opposite? Isn't the constitutional mandate saying that the Supreme Court, to the extent of how it regulates practice and procedure, will do it itself, because that is in its own internal matter, and the only thing that's stopping the rule-making ability is anything expressly provided in the Constitution or by law. Like I said yesterday, limitation hai, court fee hai, is tarah ki cheezein hai, which are procedure related, which you can't override through your rules. So ek system bana hua hai, uske andar they govern themselves internally. And it's interesting that in these 3 days of hearings, nobody has actually said to the Supreme Court that this is your rule-making power. What is stopping you today from making these rules? And why don't you exercise this power and call a full court meeting and actually exercise this power and bring it? We're ready to argue this point and go into the delicacies of subject 2 and whether this is an expansion of jurisdiction or not. और आपके मुताबिक तो सुप्रीम कोर्ट अपील की राइट भी दे सकता है. So problem किधर है?
If appeal is read into as procedure.
The point is कि अगर हमने independence of the judiciary को guard करना है तो where is the limit? कहाँ guard करें? Guard करें?
Your ladyship is.
What principle should I follow?
Your ladyship is absolutely right. There is nothing stopping the Supreme Court from reforming itself, but a much more fundamental principle is involved.
Example, just to quote an example, in Germany and in South Africa, they have adopted the concept of the lawful judge, and I'm sure you must be aware of that. और उसके लिए उन्होंने 11 criteria laid down किए हैं कि how the cases are fixed and before which judges they will be fixed. So there's no intervention by any master of the roster. It's all through, if the Parliament tomorrow